Hey everybody, this is Abigail Mabry with Cobb Law Group and CINA of Nashville, and I am an immigration attorney. I wanted to come to talk to you today just to answer some questions that we get pretty often. So one of the questions that we get pretty often in consultations or from current clients is, let's say somebody comes in and they say, I obtained my permanent residency through marriage, but now I'm separated from that spouse or I'm divorced from that spouse. What are my options? And that's a really good question, and it's a pretty common question that we get fairly often. So let's say, for example, that somebody obtained their permanent residency through marriage, and they got their permanent residency when they had been married for less than 2 years. Okay, so let's say they were married for a year and then they got their green card. So married for less than 2 years when they got their residency. In that type of situation, they usually get what's called a conditional residency, which means that their residency is only good for 2 years. And then they have to submit what's called a petition to remove conditions on their residency, like 1 year and 9 months after they get their permanent resident approved. So in that situation, that petition to remove conditions on your residency is something that you have to file jointly with your spouse if you're still married. But if you're not married anymore, you're separated, then you can file it by yourself, but you have to provide more evidence usually as to like what happened in the marriage, right? Why did you get divorced? What was the situation there? So when they submit that petition, they have to provide evidence that their marriage was real, that it was a genuine marriage, it just didn't work out for whatever reason, and then some explanation as to what happened for the immigration office to approve that petition so that they can get that 10-year green card without any conditions on it. So that's the type of situation that happens when somebody is married for less than 2 years when they get their residency, and then between the time that they get their residency and when it comes time to apply to remove those conditions, they get divorced or they separate. Something that also happens a lot is that people will get their residency through marriage and they will want to apply for citizenship at some point. Well, if you want to apply for citizenship and you got your residency through marriage and you're still married to that person and you're still living together, then you can actually apply for citizenship only 3 years after you get your residency. But if you're not together anymore, you're divorced, and you got your residency through marriage, you actually have to wait until you've had your residency for 5 years before you can apply for citizenship. So those are a couple of the situations that we see a lot with people who obtain their residency through marriage and somewhere along the way they've gotten divorced or they've separated, and they want to know what their options are, either to have the conditions removed on their conditional residency or to be able to apply for citizenship based on having been a resident for a certain amount of time. So I hope that that helps everyone, that provides some information that could be helpful to you or to someone you know that may have one of these questions. If you're in this type of situation or you know someone who is and you want to do a free consultation with our office so we can talk to you about your options, we would love to hear from you, and you can call us at 615-649-0049. Send us a message on Facebook. And we would love to get you set up with a free consultation to talk about your immigration options. Thanks, everybody.